Good Sunday morning and welcome to Inside Tennessee. I'm John Becker, and our topic this morning centers on life and death and the recent decision by state leaders to resume executions after a pause lasting almost 2 years. Before our discussion, a quick history of the death penalty in the state of Tennessee. Since Tennessee became a state in 1796, leaders have allowed official executions on and off for more than 200 years. The state says executions peaked in the 1930s at 47 executions. For most of the 1970s, a decision by the U.S. Supreme Court ruled capital punishment unconstitutional. Throughout history, the state has authorized 3 different forms of execution: hanging, electrocution, and lethal injection. Now, here is a look right now at death row. 46 inmates, including one woman, 48-year-old Krista Pike, sent to death row in a Knox County case back in 1996. One of the 14 from East Tennessee on death row. The longest tenure for a death row inmate right now is 42 years. The last execution in this state was in 2020, just before the pandemic drove Governor Bill Lee to issue a reprieve. The governor went on to order a review of the lethal injection protocol, and recently state leaders cleared the way for executions to resume. I am joined this morning by my colleague Brittany Bailey. She's an investigative journalist and has researched and worked on reporting several different death penalty cases in several different states. We're glad you're with us, Brittany.
Thanks. Glad to be here.
Our guests this morning include veteran defense attorney Don Bosch, who has worked exhaustively on these difficult cases. Don, good to have you.
Good morning.
And District Attorney General Jared Effler supports the death penalty, serves the counties of Campbell, Claiborne, Fentress, Scott, and Union as District Attorney General for District 8 and has for a decade now. General, good to have you.
Good morning.
So, gentlemen, Don, you are typically a panelist for this broadcast. Yes. You are one of our guests because you oppose the death penalty. Why?
Well, there are 3 basic reasons for me. One, Jared, I think, would agree that we work in the greatest judicial system in the world. It usually and almost always works. But when we mete out punishment, if we're wrong, we can correct everything that we've done, at least to a degree, except a death sentence. Humans are fallible by their design. And so it is the one punishment that you cannot reverse. 2, I don't trust my government enough to decide which ones of its citizens it's going to kill. And I know that's a harsh way to say it, but we have seen too many disparities and inequities nationwide in who is subject to the death penalty. We can even see it in Tennessee to the degree of how it breaks down racially, economically. There's not a single person on Tennessee's death row that had retained counsel. And then 3, at the end of the day, it's incredibly expensive. A lot of people think, well, shoot, A, we should just kill them quicker, and we can't, okay, because there are too many due process rights involved, and there should be. And B, it really is less expensive to incarcerate somebody for life and has an effective deterrent in doing that. So those are the 3 broad reasons for me.
General Effler?
Well, personally, I believe that we live under a representative form of government, and the majority of Tennesseans believe that the most heinous offenses in our state should be subject to the ultimate punishment. I personally believe that. Also, I believe by not having the death penalty for those heinous offenses, for mass murder, for instance, when we talk to a victim's family and we say, well, we are sorry for your loss, but all we can do is put this person away for the rest of their natural life. That's just not sufficient, and that is appreciating the seriousness of those heinous offenses and not allowing us to seek justice on behalf of those victims.
Well, let's talk about the recent changes. Now Tennessee is going to start potentially executing folks once again, going from that 3-drug cocktail down to a 1 because of the problems. This one, though, critics still say they have concerns about it. Some have likened the effects of this one drug to waterboarding. Do you all have any concerns about using this one drug now in Tennessee?
I do not. If you go back to 2000, which is really the breaking point where we switched from electrocution to lethal injection, we have gone as a state back and forth between the 3-drug protocol and a single drug protocol. And I believe that the 1-drug protocol, there's simply less room for error because we're analyzing 1 drug versus 3. And when you look back to the problems that Governor Lee had or the concerns in 2022, it was really with the analysis, the review of those drugs, how they were being done, and they weren't being examined for endotoxins. So 1 drug examination is much easier to accomplish, and it's much easier to get right than going through that 3-drug analysis.
Well, I think General Effler probably went to more chemistry classes and biology classes than I did in school, and so I'm not an expert on the pharmacology of it, but I have read the literature on it. I do have concerns, and again, there's no question that the punishment meted out, even a death sentence, cannot be cruel and inhumane. And I know there are people out there in the public, particularly victims, say, I want a defendant to die the way my loved one died. And that's not who we are as a society. So that said, I have concerns that even this protocol may yield, on occasion, situations where there is unusual amounts of suffering that might go on for somebody that's being put to death.
Another piece of news tied to the death penalty is the AP and the Associated Press saying we want to see transparency from the state on the process and how it will happen. General, right now the state has denied that.
Well, that is an issue really for the State Attorney General's office, but I can tell you what is public, John, is the independent investigation, the results of that investigation that Governor Lee ordered when he had concerns about the protocol. And I reviewed that, and I think that's very telling. And that investigation determined that the state of Tennessee overwhelmingly wants to get the process right, and they want it to be transparent, and I believe that.
So it's one thing to want to get the process right versus show us the process, whether those of us like myself think it's flawed, show us that it's right. I'm not speaking to Jared and his office's review, and I think of Sharm Allen and her predecessor, Randy Nichols. The reviews were fairly done as a review goes, irrespective of whether you disagree with it. It's what the state is going to do, and frankly, I'm very concerned that we're not seeing all the backstory on how this is going to happen.
We're going to have more to come on this discussion with Brittany, General Effler, and Don Bosch about the death penalty and the resumption in the state of Tennessee after a short break on Inside Tennessee. We're back on Inside Tennessee with a discussion of the death penalty resuming in the state of Tennessee after a review ordered by the governor. With us is District Attorney General Jared Effler of District 8, Don Bosch, who opposes the death penalty, and Brittany Bailey. She's an investigative journalist who has handled a number of death penalty stories.
Well, gentlemen, let's start off talking about this segment about the prevalency of the death penalty. We're talking about the importance of these cases, but frankly, they don't happen that often here in our region.
That's a good point, Brittany. I think it's worth pointing out that right now there are 127,000 people in Tennessee under the restraint of our criminal justice system. Only 44 of those have a death sentence hanging over their head. That's less than 1% of everyone that the state of Tennessee has put a constraint on are on death row.
Yeah, it is a small number in the state of Tennessee. We have had the death penalty. We have been reluctant to use it, reluctant to impose it, reluctant to seek it generally. I would say that Memphis is probably the market that seeks it the most in Shelby County. But it's still significant, and it still sends a message. The South, unfortunately, is in what we call the death belt, and where many of the states still in the southern jurisdiction have the death penalty. Many states have abolished it. But in Tennessee, if you can call it fortunate, we have a very low number, and it's infrequently used and takes quite some time, largely because we've had a lot of problems in this state administering it, both from a legislative scheme and now from, as we've seen recently, the drug cocktail protocol problems.
To both of you, and General, we'll start with you, but is the death penalty used in criminal prosecutions as a bargaining chip often?
No, it's not. As a prosecutor, I only seek the death penalty in cases where I think it's appropriate. It should never be used as a bargaining chip, because anytime we talk about seeking the ultimate punishment, that is a very solemn occasion, regardless of the heinous nature of what we're talking about. And we should look at it as that. We're seeking to take someone's life, and does the facts of this case and the circumstances support it?
Does that philosophy?
I will say, Absolutely. Jared Effler has never used it. In my knowledge, we have not had a death penalty case together. I've never heard or seen Jared use it that way. I have had it used exactly that way. Either you take this deal or we are going to notice you for the death penalty. And I can think of 3 cases right now that I've been involved in where that has happened in my 37 years, and that's troubling. I've seen another case, literally, where the selection or the appointment of a particular lawyer in a case who was a thorn in a lot of prosecutors' sides over the years, literally said, but for this lawyer being in it, we wouldn't seek the death penalty. So I have seen it used inappropriately. Again, I can say that Jared has never exhibited or discussed it in that manner.
Well, I can say the colleagues that I work with across Tennessee, there's 32 elected district attorneys in our state, and our statutory scheme of when we can seek the death penalty is very, very restrictive. And I think when you look at the number of people on death row, that shows you that Tennessee's district attorney, that we are following that statutory scheme.
And going back to the people on death row and many who have been there for a long period of time, many cases it's because there's such this long process, the legal process that has to play out. And it can be very challenging to get the proper folks to handle those. Do you ever feel like it can be improperly or unfairly done in different parts of the state, whether you're dealing with an office that has less experienced folks or not enough folks to handle a death penalty case? Have you seen that play out? Is that a concern when this is across the board in Tennessee?
It's not a concern for me, Brittany, because as you know, we have a 3-tier review process in any death penalty case. And in that 3-tier process, there's 13 steps. And before someone can be sentenced to death in our state, there's literally scores of jurors and judges who are going to review that case. And then ultimately the decision will rest with the governor of the state of Tennessee of whether or not he or she wants to grant relief in that particular case. So, no, I am more than confident that the system that we have is the best in this, the entire world, and that I have confidence in our system that we're getting it right.
How big a role do families of victims play in talking to prosecutors about the option of a death penalty?
Ultimately, John, it's always our decision as the elected district attorney. But I believe as a district attorney, I owe it to that victim's family to listen and take into account what their feelings are. Ultimately, it's my decision, but as a district attorney and abiding by the state's constitutional victims' rights, I have to listen to those victims, and not only do I have to, I want to.
So I've, again, had a different experience with other prosecutors. Prosecutors are no longer in the office, where the family, I've watched the family particularly push very, very, very hard for a tragic and a terrible murder, but not one that was, I would say, horribly heinous or unusual. And they were able to push the prosecutor into noticing for death penalty. And that's the distinction. What Jared talked about is what happens leading up to after the notice has been filed. The simple fact that a notice is filed that you will have to defend this as a death case, which changes the entire equation, that's really as much as a problem as anything else.
We'll dig into the complexity of those cases with both of you. And Brittany, we want to hear more of your background as well in reporting some of these death penalty cases early in your reporting career. We'll be back with more of that conversation right after this. My colleague Brittany Bailey is joining us on this Sunday morning because, Brittany, you have experience in several states covering death penalty cases and also working as a young journalist on death penalty cases. Explain a little of that history.
Yeah, when I went to Northwestern University for my journalism undergrad, I worked in David Protest's investigative journalism class, and he created the Innocence Project. And so I helped to investigate death row cases where the victims, or the suspects rather, had declared their innocence. And we looked at cases, me personally, in Illinois, where Northwestern was, Indiana, and Texas. And in the 3 cases that I really focused on, they had different endings, and I think that's the point here. We were sort of really wanting to find the truth and where the evidence led us. I think a lot of people would look at this, class and say, you were just trying to get people off of death row, and that was not what we were doing. We were trying to hone our skills as journalists at the time. And to let you know what happened with that, Stanley Howard was the gentleman who was on death row in Illinois. He was part of the Death Row 10, pretty famous 10 cases. He was pardoned by the governor for those crimes. A case I worked on in Texas, Hank Skinner, he actually died in 2023 before anything came of his case. And then a case I worked on in Indiana, Perry Miller, he was guilty of the crime. And he was, while he eventually was pardoned for one crime. He then committed, or rather, was convicted on another crime and is still in jail. So
I think they were commuted. Their sentences are commuted versus pardoned.
And so, Don, speaking of the Innocence Project, it may be something that lots of our viewers have heard about. Explain that and what the evolution of it is.
Very familiar. I actually had a brief interchange with Barry Scheck, one of the other founders, just this week. And what it is, it was basically a cold case review taken on by a combination of journalists, law students, Innocence Project clinics, where they were looking at things. And remember, when this started, it really became the advent of DNA evidence. It got honed and well looked at. And before, you know, a lot of these cases rested solely on eyewitness evidence, for example. And we know, and Jared will likely tell you as well, eyewitness testimony can be challenging for either side. And so these clinics popped up all over the United States, really beginning in the late 80s and early 90s. And again, I'm most familiar with Barry Scheck's role in it. And Barry was, if you remember, the famous lawyer in O.J. Simpson that sort of turned that case for Mr. Simpson. But it really has done a good job, and we have discovered that there are a number of people, not only on death row, but in prison on life sentences or very long sentences, that were exonerated as a result of the work of the Innocence Project.
General, the last thing as a prosecutor you want to do is make a mistake. When you say this case rises to a death penalty, that triggers a whole bunch of changes to how you treat the case.
As it should. Our death penalty cases should be the most scrutinized in our judicial system, because as a prosecutor, we always want to get it right, especially in a death penalty case. But our founding fathers, way back in 1796, they determined that those heinous crimes should be subject to the ultimate punishment. That was before the advent of DNA, before we had surveillance video. Well, fast forward to today, and we should have more confidence in our verdicts today than at any time in history, because we do have DNA, we do have advances in technology. So much of what we do is under a surveillance video. How are we going to say when a mass murder is committed and captured on surveillance video that that person is innocent? And those tragedies, we should have the death penalty as an option as prosecutors.
So the only thing I will say is, you know, Jared takes, and understandably so, the easy case, the mass murderer, and uses that. But there's a slope, and where do we draw that line? And my question I always have when I talk about this with those that support the death penalty or think that it's an appropriate punishment is, what's the percentage of error that's acceptable? If we kill one person that's wrong, 5 people, what's your percentage of error?
For our viewers, is there any case in Tennessee identified as a mistaken case of someone executed who didn't commit the crime?
Well, if you're going to talk modern times, I'm unaware of anything in modern times. I think certainly when you go back to the history of the death penalty in Tennessee, there have been a number of people wrongly convicted. And you remember prior to 1960s, you could be executed for rape in this state. And I looked at those and I think of all the people that were executed for rape, again, you want to go to the racial disparity, there were 3 individuals that were white and there were 30 plus that were African American.
Any context to add?
Well, I would just say to that our appellate courts have never ruled that Tennessee's death penalty is unconstitutional based on racial disparity. That is an argument that's often raised, but it's never held merit.
Okay. We're going to take another quick break on Inside Tennessee, back to wrap up our discussion on this and the state of Tennessee opting to resume the death penalty right after this. Back on this Sunday morning on Inside Tennessee, we hope you've recovered from the snowstorm.
Certainly. We want to start off talking about some of the workload that this can have. We talked briefly and touched on the cost, and just a little note here, a stat from the Death Penalty Information Center, that death penalty cases can on average cost about $700,000 more to prosecute than your average murder case. But what does it mean for the workload on your offices?
I think for a jurisdiction like mine, which is a rural judicial district, I have 5 counties. It's almost like taking on an additional county. It's very taxing, it's very work intensive, and it should be, because again, we want to get it right as prosecutors, and that work is very much worth it because we want to get it right on the front end and then see that conviction withstand scrutiny all the way through the appellate process.
Yeah, and they are, I'll use the word devastating on private practitioners that get appointed typically or even would get hired on a death penalty case. I've been actually hired on one and appointed on several throughout my career. They shut your office down as a private practitioner. They are all consuming, and I know my colleague David Eldridge, for example, we talk. We're now in the twilights of our careers. We're in the peak of it, but we don't know that we would be able to take another one of those on at this point because they are all consuming, particularly on the defense side of the market, where if you make a mistake, you might get your client killed.
You mentioned this off camera, Don, but we looked at the longest tenure of death row right now, 42 years, an inmate has been on it in the state of Tennessee. You touched on it, but a lot of people would say, if you're going to have it, why doesn't it happen faster?
Well, remember, Tennessee is unique. We have had a number of problems with our death penalty statute over the years, both with the statute and then most recently with the protocols on the 3-drug cocktail versus now just going to phenobarbital as a single agent for execution. You may remember there were a lot of issues nationwide with the use of the electric chair being cruel and inhumane as well. So we've had problems in our state managing the death penalty, and that has caused much of the delay. Now, I will say that it is a fair argument if you're going to have a death penalty. You have to have the due process. 42 years is extreme. We've had more people die on death row in the recent times than have currently been executed. Again, another argument for true life sentences because it brings a lot more immediate finality at, frankly, a more economic cost to the state and to the taxpayer. And those folks don't get out of jail. I have one client that is doing life without the possibility of parole, and he's not ever going to get out of jail.
Your take on that length of time?
It's frustrating. The average tenure of someone sitting on death row right now in Tennessee is almost 25 years. There's been previous efforts by the legislature to streamline the appellate process. We tried to, in 2017, do away with an appeal directly to the Court of Criminal Appeals and make those direct appeals go to the Supreme Court. Unfortunately, that failed. It's something that personally I wish the legislature would revisit on how can we streamline the process. Because what's frustrating as a prosecutor, what often happens when these inmates, these violent offenders, sit on death row for decades, the victims lose their voice. You know, the last person that executed out of the 8th Judicial District, Stephen Michael West, had been on death row for 33 years when he was executed.
That was a function of, in large part, of the bad statute in Tennessee.
And it was a function, Don, of the victim's father, the victim's husband in that case, died before he saw the will of the juror carried out. And again, that's very frustrating because, in my opinion, justice was never served in that case.
Yeah, and we should never rush the government's decision to execute one of its citizens, even its worst. And that's why we need the due process. It does need to be moved faster, but steps do not need to be called out.
Only about 90 seconds left. Brittany, what would you leave our viewers with today in considering the restart of this process?
Well, that would be the question I would pose to you all before we leave is, are you anticipating any problems with this coming back? Do you think that people are going to protest this? Do you think that there will be more pauses? Are we back on track, or are we just going to continue to see what we've seen in recent years?
Well, I think the death penalty is a topic that engenders strong emotion on both sides, and I appreciate the opportunity to sit down and be able to discuss this in a civilized manner. Unfortunately, not everyone does that. And I anticipate that those emotions will come to the surface again, but I have faith in our system that they will get it right, that the appellate courts will look at it and take the appropriate action.
There will be appeals, there will be protests. I think there are going to be problems. And when I say problems, legal problems. And there's more to come in terms of whether this is going to play out ultimately as the method that we execute people and whether it speeds it up.
Don Bosch, General Effler, we appreciate your perspective, and thank you both for agreeing to come on and talk civilly about this.
My pleasure.
Thank you.
And Brittany, we appreciate your expertise as well, joining the panel this morning. We thank you for watching us on this Sunday morning. Have a great start to the rest of your week, and we'll see you back here next week on Inside Tennessee.